The question is that clause 4's then is printed. Member for Johnson.
Thank you, Chair. Minister, what consultation occurred with domestic violence services or organisations in relation to these changes?
Member for Johnson, we consulted with police and the Attorney General's Department.
So no consultation with domestic violence services, and I presume also no consultation with mental health services or organisations?
Is that a question?
Clarification. Was there any consultation with mental health services or organisations?
The consultation was with police and the Attorney General's Department.
Thank you. So no consultation. Minister, what's the purpose of the current 28-day waiting period?
Member for Johnston, there is a mandatory 28-day waiting period before the Commissioner can grant a permit to a person unless an exception applies. This amendment provides an additional exception to the 28-day waiting period for category A and B firearms. Applicants will now be able to apply for the extension on the 28-day period where the prescribed checks have been completed and either the applicant holds a licence, owns a registered firearm and has established a genuine need for owning the firearm to be purchased or acquired, or the permit is for a category A or B firearm and the applicant holds a licence for the category of firearm to be purchased or acquired and they already own a registered firearm of the same category of firearm to be purchased or acquired.
Thank you. Sorry, my question might not have been clear. It was actually what's the purpose of the 28-day waiting period, not what's the change?
Member for Johnston, the rationale comes from the National Firearms Agreement, which constitutes a national approach to the regulation of firearms and affirms that firearm possession and use is a privilege that is a conditional on the overriding need to ensure public safety. Therefore, Clause 43 of the National Firearms Agreement provides that the issuing of permits is to be subject to a waiting period of at least 28 days.
And Minister, what's the rationale for not following the National Firearms Framework?
We are still following the National Firearms Agreement.
Minister, you just read out that the agreement says a minimum of 28 days. Is that correct?
I can help answer that. Section 35, subsection 4 says that you can't purchase a firearm until the end of a 28-day period. That section is not being changed, so that complies with the National Firearms Agreement. What we're doing after there's a exemption, we're just amending the exemption. So 28 days still apply for all the other categories of firearms, and we're just allowing an exemption. So we're still complying with the National Firearms Agreement because it says there 28 days. We're just putting an exemption in, which is already there.
You're putting an exemption in, which means that people can get a firearm in less than 28 days. Is that correct?
Yes, that's correct. And you could do that. That's already been part of the law for 25 years.
So we've already not been following that national framework, and now we'll just not be following it a little bit more?
No, we're following it, but there is an exemption.
Okay. What is the current averaging processing time for firearms applications?
It really depends on the applications that are coming in. There isn't an average.
How many applications take the full 28 days?
It doesn't work like that, Member Johnson. When you ask how long it takes, it depends on what month and how many applications you put in per month. So the starting period is you put in an application and there's 28 days. If you apply for an exemption under the current law, which has been for 25 years, the Commissioner may grant an exemption And what we're doing, we're just clarifying what those exemptions are. So the law is still 28 days. Then you can apply to the Commission for an exemption, which is section 35, subsection 5.
Thank you. Minister, is there real-time notification to the Police Commissioner when a registered gun owner becomes the subject of a domestic violence order?
Yes.
Is there real-time notification to a firearms dealer?
No, because the firearm dealer isn't party to a domestic violence order. If you become, police issue a domestic violence order application on you and you get an interim order, the police will come round as soon as possible, as soon as the police are free, and they'll take all your guns off you.
So if someone applies for a firearms permit during the period between a DVO being issued and that information reaching the firearms registry, what would happen?
Well, it's instant, because if you get an interim, like the police, if there's a domestic violence event and the police are called, they choose whether they put an interim order on you, and once they do it, as soon as that happens,
it's instant?
Instantly they come and, if they come to my house and I had a domestic violence event with my wife, they would come and arrest me and take my guns.
Okay. So there would be no circumstance where someone could there'd be a gap between when they got a DVO and when they...
As soon as an interim order is put on by the police, and that's who put on interim orders, the police will then, as soon as practical, because the police could get called to a murder somewhere else, but like I said, if they come and arrested me, an example, because there was an event at my house, they would take me away and they'd take my guns.
Thank you. What safeguards exist to prevent firearms acquisitions during periods of mental health crisis?
That's not relevant to this clause because you've got the 28-day period. We're just talking about exemptions.
Well, I think it is relevant. If someone already has a licence and they're undergoing a mental health crisis, what safeguards exist?
That's not relevant to the clause.
Huh? Yeah, oh yeah. I'm unclear how it's not relevant to the clause. We're talking about not having the 28-day period if someone already has a licence, expediting that.
We do have a 28-day period, matters as a Deputy Speaker, so it's not relevant to the clause.
Does the current requirement to demonstrate genuine need apply to each individual firearm?
If you apply for the exemption, yes.
Thank you. Is there any limit to the number of firearms that people can own in the Northern Territory?
It's not relevant to the clause. But the answer is no.
The answer is no.
Hasn't been for 25 years.
Okay, that's all I have on this clause.
Okay.
Thank you.
The question is that clause 4 standards printed. Those that opinion say aye, the contrary no.
Aye.
I think the ayes have it. Question is that clause 5 standards printed.
Aye.
Those that opinion say aye, the contrary no.
Aye.
I think the ayes have it. The question is that clause 6 standards printed. Those that opinion say aye, the contrary no.
Aye.
I think the ayes have it. Okay. Question is that clause 7 standards printed. Attorney General.
Mr Deputy Speaker, I move Amendment 1 that the clause 7(1) be amended as drafted. Clause 7(1) of the Attorney General and Police Legislation Amendment Bill 2025, the bill, amends Section 5(6) in brackets of the Information Act 2002, which I refer to as the Information Act, to replace references to Parliamentary Secretary with references to Assistant Minister. That proposed amendment was essentially a like-for-like swap to reflect current terminology and practices and cater for future possibilities of that title. Amendment 1 will now see clause 7(1) simply remove reference to Parliamentary Secretary. The rationale for the proposed amendment is that as the office of Parliamentary Secretary has never been formally established and the position of Assistant Minister is likewise not formal, the position has no ministerial responsibilities under a ministerial portfolio. References in the Information Act to Parliamentary Secretaries or Assistant Ministers is without functional purpose. Should the functions of Assistant Minister be formalised at some future point, the Information Act can be amended to accommodate that.
Okay, the question now is that the amendment be agreed to. Are there
No.
any speakers?
No.
Member for Guadja.
So just speaking to that Attorney General, I'm just seeking your confirmation. You said that assistant ministers are not formalised, so are they just a title? It's just a name.
Yes.
Thank you. And I think that there are further questions from my colleague. Yeah, that's just the assistant
So
minister.
we're talking about Amendment 1?
Yep. Thank you, Minister. So just want to get an understanding again why you have admitted Assistant Minister and what's the rationale behind that?
Like I said, the rationale for the proposed amendment is that as the office of Parliamentary Secretary has never been formally established and the position of Assistant Minister is likewise not formal, as the position has no ministerial responsibilities under a ministerial portfolio, references in the Information Act to Parliamentary Secretaries or Assistant Ministers is without functional purpose.
Thank you, Minister. So with that, just wanting clarification that now, because previously you had Assistant Minister in the legislation, so I'm just wanting to get clarity that now an FOI process can take place to an Assistant Minister.
Just to clarify, Assistant Ministers do not have government information.
Yes, but an FOI can now take place to an Assistant Minister now that that's been removed.
Member for Daly, an FOI doesn't apply to backbenchers.
Thank you. I just wanting clarity on that because originally when it was inserted, the intention for this was that every single member on your CLP side wouldn't be able to come under scrutiny. So I just wanted to get clarity on that if an FOI process was to take place. No further question. Oh.
Member for Daly, it was just a like-for-like swap with the Parliamentary Secretary.
Okay. I'm just reminding people we've got 5 amendments to this clause. We'll go through them one by one, just so that's the way to do it. So just following on from there, the question is that the amendment be agreed to. Those that have opinion say aye, the contrary no. Aye. I think the ayes have it. The question now is that the clause stand as amended. Are there any speakers? No? Okay. So I call on the Attorney General.
For clause 7, amendment 2, I move amendment 2 that clause 7.2 at line 20 be amended to omit an assistant minister. The rationale for the proposed amendment is the same as that for amendment 1, which I've been through, in that as the position of assistant minister is not formal, references in the Information Act to assistant ministers is without functional purpose. Should the functions of assistant minister be formalised at some future point, the Information Act can be amended to accommodate that.
The question now is that the amendment be agreed to. Are there any speakers? No? The question is that the amendment be agreed to. Those that have opinion say aye, the contrary no.
Aye.
I think the ayes have it. The question now is that the clause stand as amended. Are there any other speakers? No? Attorney General.
I move amendment 3 that clause 7.2 at line 21 be amended to omit assistant minister. The rationale for the proposed amendment is the same as that for amendment 1, in that as the position of assistant minister is not formal, references in the Information Act to assistant ministers is without function nor purpose. Should the functions of assistant minister be formalised at some future point, the Information Act can be amended to accommodate that.
The question now is that the amendment be agreed to. Any other speakers? No? The question is that the amendment be agreed to. Those that have opinion say aye, the contrary no. Aye. I think the ayes have it. The question now is that the clause stand as amended. Are there any other speakers? Attorney General.
Thank you. I move Amendment 4 that clause 7.2, line 28 be amended to omit entity and replace it with entity. The rationale for this amendment is to grammatically support the omission of paragraph C in proposed subsection 5(6)(a) in the bill.
Question now is that the amendment be agreed to. Are there any other speakers? No? The question is that the amendment be agreed to. Those of that opinion say aye, the contrary no. I think the ayes have it. The question now is that the clause stand as amended. Are there any other speakers? Attorney General.
I move Amendment 5 that clause 7.2 be amended to omit paragraph C of proposed subsection 6A. Clause 7.2 in the bill is intended to clarify and confirm that any information created or received by the Minister or a Minister's staff and shared within the Minister's office or with other Ministers' offices, but not with other public sector organisations, i.e. a department, is exempt from the Freedom of Information applications. Amendment 5 is intended to put the issue beyond doubt.
Question now is that the amendment be agreed to. Are there any other speakers? The question is that the amendment be agreed to. Those of that opinion say aye, the contrary no.
Aye.
I think the ayes have it. The question now is that the clause stand as amended. Are there any other speakers? The question is that the clause stand as amended. Those of that opinion say aye, the contrary no.
Aye.
I think the ayes have it. The question is that clause 8 stand as printed. Attorney General.
I move Amendment 6 that clause 8 be amended to omit clause 8 as it is presently drafted in the bill and replace it with a revised clause 8 to remove the reference to Assistant Minister. The rationale for the proposed amendment is the same as that for Amendment 1, in that as the position of Assistant Minister is not formal, references in the Information Act to Assistant Ministers is without functional purpose. Should the functions of Assistant Minister be formalised at some future point, the Information Act can be amended to accommodate that.
The question now is that the amendment be agreed to. Are there any other speakers? The question is that the amendment be agreed to. Those of that opinion say aye, the contrary no.
Aye.
I think the ayes have it. The question now is that the clause stand as amended. Are there any other speakers? The question is that the clause stand as amended. Those of that opinion say aye, the contrary no.
Aye.
I think the ayes have it. Moving on to clause 9. The question is that clause 9 stand as printed. Attorney General.
I move Amendment 7 that clause 9 be amended to omit clause 9 as it is presently drafted in the bill and replace it with a revised clause 9 to remove the reference to Assistant Minister. The rationale for the proposed amendment is the same as that for Amendment 1, in that the position of Assistant Minister is not formal. References in the Information Act to Assistant Ministers is without functional purpose. Should the functions of Assistant Minister be formalised at some future point, the Information Act can be amended to accommodate that.
Question now is that the amendment be agreed to. Are there any other speakers? Question is that the amendment be agreed to. Those of that opinion say aye, the contrary no.
Aye.
I think the ayes have it. The question now is that the clause stand as amended. Are there any other speakers? The question is that the clause stand as amended. Those of that opinion say aye, the contrary no.
Aye.
I think the ayes have it. Is it the wish of the Assembly that the remainder of the... Oh, sorry. Are there any other clauses? Sorry. 10? Sorry. Thank you. Question is that clause 10 stand as printed. Member for Johnson.
Thank you, Chair. Minister, what constitutes official portfolio business?
10. Is that on there? Member for Johnson, the Administrative Arrangements Order sets out our ministerial responsibilities for areas of government. The amendments seek to clarify the long-standing position that information created or received by a minister or their office is not subject to freedom of information requests regardless of what it relates to.
So who determines... sorry, did you say regardless of what it relates to? I didn't quite catch that. Okay. So if minister discusses something in an informal communication, is that official portfolio business, or could that be official portfolio business?
Sorry, can you repeat that?
If a minister discusses something, for example, mining approvals in an informal communication, would that be official portfolio business?
That one's irrelevant to this clause.
Which clause would that be relevant to?
Clause 7 that we just went through.
Okay, this another question. Tell me or not. Tell me if it's relevant or not. What appeal mechanism exists if someone believes information has been wrongly classified as portfolio business?
If it's within the minister's office, it's excluded.
So there is no appeal mechanism?
No, because the work that's done in the minister's office is excluded.
So if someone believes it's been wrongly classified as, so if it's in the minister's office, it's if it's directly related to the minister's portfolio, is that, or it's just anything that the minister does?
Yes.
So if it was the Minister for the Prevention of Domestic Violence and it was communication about the environment, that would not be related to their portfolio?
I just wouldn't have any portfolios.
Any portfolio, so not directly the Minister's portfolio, but any portfolio?
So what happens in a minister's office, it happens in a minister's office. There's no other way of getting around that.
That's fine. I'm just seeking to clarify. So any ministerial communication about anything related to any portfolio by any minister is not FOIable. Is that correct?
Yes.
And there is no appeal mechanism if someone believes that's it should be?
No.
Thank you.
Okay. The question is that clause 10 stand as printed. Those are the opinions say aye, the contrary no. I think the ayes have it. Are there any other clauses people wish to? If not, is it the wish of the Assembly that the remainder of the bill be taken together? There being no objection, it is so ordered. The question is that the remainder of the bill stand as printed. Those that opinion say aye, to the contrary no. Aye. I think the ayes have it. The question is that the bill be agreed to. Those that opinion say aye, to the contrary no. Aye. I think the ayes have it.